Well, hi, my name is Kara Ronnau. I'm a lawyer here in Lincoln. I also practice in our Aurora office. I'm there most of the time. One of my practice areas is employment law. I don't know if all of you have heard, but this presentation and topic became, I don't want to say less interesting, but it's going to be different because of a development in the law. So it's exciting in that way. Last Tuesday, I first started reading about it in the evening, actually. A federal judge in Texas granted a preliminary injunction which basically stops this rule from going into effect on December 1st. It was supposed to go into effect this Thursday. So that would be 9 days before it was to go into effect. A judge entered an order saying that not for now. I've been reading a lot, as I'm sure a number of you have, about the likelihood of success now. And I don't think that anybody can really speak to that definitely at this point. But there are a number of opinions that the change in administration will make it less likely that this rule ever goes into effect. And with this preliminary injunction and this pending litigation, there's actually a possibility that it'll kind of die on the vine if the department doesn't vigorously try to prosecute this suit and defend the lawfulness of the final rule. So with all that said, I'm going to go through what the final rule means if it is implemented, how it changes the current structure, what employers should have done to implement it or might be doing to implement it. I have a number of clients who have already made the changes to comply with this rule. So we'll talk about that. A lot of the language that I'm going to use is going to be different than what you'll see on the slide just because it's not mandatory now. Employers don't have to be complying with this rule by December 1st. It could be a long time, if ever, that they do have to comply with it. So kind of bear in mind with that as you look at these slides and as you listen to me, and if you look over these later, just all of it hinges on whether or not the law is ever actually implemented now. Maybe I turn the... Oh, there it is. Perfect. So this is what the presentation is going to cover. What are the changes? We'll talk about, the current law, which was the latest revision was 2004. That's the current law. That's going to stay into effect, at least for now. What steps employers can take to implement the changes of the final rules, and just challenges that go along with implementing this rule, or at this point, maybe trying to unimplement the rule. That's a conversation I've been having since Wednesday morning. The Fair Labor Standards Act, it's a federal law. It establishes minimum wage requirements, overtime pay requirements, record-keeping requirements, as well as youth employment standards. It also establishes exemptions to the minimum wage and to overtime, which is what was changed by the final rule, are how those exemptions are applicable to employees. Employees are covered employers. Employers are covered employers. Our employees are covered by the FLSA unless they're otherwise exempt. And what that means is that they have to be paid minimum wage, and which is $7.25, I think, still. And they have to have time and a half for hours worked over 40 in a work week. So how do we know if an employer is actually even covered by the FLSA? That's always your starting point. There are two different types of coverage. The first is enterprise, and then there's individual coverage. Enterprise coverage, you have to have 2 employees, and there has to be annual volume of sales or business in excess of $500,000. And that means that you're a covered employer. You have to comply with the regulations of the FLSA. Or another type of enterprise coverage, 2 employees, if you're a hospital, a business providing medical or nursing care for residents, a school or preschool, or a government agency. That's all encompassed in enterprise coverage. Then there's individual coverage. So even if there is an enterprise coverage, you still need to ask, are any of the individuals employed here covered under this type of coverage? That's when an individual is engaged in work that regularly involves interstate commerce, which is a very broad standard. The bottom line is that most employers are covered by the FLSA, either through enterprise or an individual employee might be. Some things to know about individual coverage is that it's based on the nature of the employee's actual work. So an employee who engages in interstate commerce or in the production of goods for interstate commerce, they would be covered under the FLSA. Or even if they're, in Nebraska but making phone calls to Colorado and California and other states, communicating, that's considered engaged in interstate commerce for purposes of FLSA application. So, how do we know if an employee meets the exemption? If you know that the employer is covered or one of the individuals employed there is covered, how do we know if they're exempted? And generally speaking, to qualify for one of the white-collar exemptions, and that would be your professional, administrative exemptions or executive exemption, the employee must meet certain tests regarding their job duties as well as a sufficient salary basis and actually be paid a salary. So the duties test, which is really what this recent blocking by the federal judge, it really just centered around the fact that this salary increase that the final rule tried to put in place, it supplanted the duties test. So it's important to understand the duties test, be able to communicate that to your clients about where the focus really should be in order to determine if they're exempt or not. It focuses on their actual job functions, not their title. So even if I have an employee and she's my legal secretary, but we're going to call her, executive, even if she has the title of executive, that doesn't mean that she automatically qualifies for the executive exemption. You have to look right down to what is she actually doing for you from day to day to determine whether or not that exemption applies. So for the executive exemption, so with this legal secretary, I'd be asking, does she manage the enterprise? Or is it a customarily recognized department or subdivision? Is she directing work for other staff members? Does that employee have the ability to hire or fire? Or even, recommend that to me or to someone else and have that be given deference? And if the answer to that is no, then the executive exemption doesn't apply. The administrative exemption, that requires that an employee perform approved work directly relating to the employer's management or general business operations. The Department of Labor website is so helpful. They have, for each of these exemptions, they have fact sheets where you can go and look at various examples of what would qualify under the administrative exemption and what wouldn't. The key word here, though, is that the employee needs to be able to exercise their discretion and independent judgment with matters of significance. Professional exemption. To satisfy the requirements for this exemption, the employee must be a learned professional who's gained equivalent knowledge and skills through a combination of job experience, military training, attending a technical school, or attending community colleges. Highly compensated exemption. To qualify for this exemption, the employee must perform at least one of the duties of an exempt executive, administrative, or professional employee is required to perform, and their salary level is different than the other exemptions. The 4 regulations that are still currently in effect have that at $100,000. The final rule has it at $134,000. But again, just like with everything else we were talking about, that doesn't actually go into effect now on December 1. Salary basis test. So the next question you have to ask yourself is the employee actually paid on a salary basis? Is the employee paid the same amount each pay period, regardless of the quality or quantity of work performed? There are limited exceptions to this. For example, personal absences and sick leave that might adjust their actual pay rate. So current salary amounts that will continue in effect until we know otherwise are $455 per week, and that equates to $23,660 a year. For highly compensated employees, that is a total of $100,000. Non-discretionary bonuses, those cannot be used to satisfy the salary amounts. There was a change to that in the final rule where a certain portion, 10% of a non-discretionary bonus amount could go toward paying up to 10% of the new salary level. So what is changing on December 1st? Nothing is the new answer. So what we expected to have changed until last Tuesday was that it would go from this $23,660 to $47,476 per year. You know, depending on how the court rules and when it rules, if the final rule is determined to be lawful, then that's the amount it would go up to. That's based on the 40th percentile of full-time salaried workers in the lowest income region of the country, which is currently the South. This will be, you know, if the final rule goes into place, another key provision is that there's an automatic update every 3 years. And so that would really be an ongoing issue that your clients need to be cognizant of for all of their exempt employees. They would have to just be aware that it's going to go up every 3 years, and if annual salaries didn't go up in that amount, they either have to reclassify the employee or pay them more if the final rule were implemented. This is what we were talking about with non-discretionary bonuses, incentives, and commissions. This, to me, the way I read this in the final rule, which is like 503 pages, it was their way of kind of giving employers a break, is how I interpreted that. They were going to, even though these amounts weren't in the past allowed to count towards the salary level, they were going to allow a portion of it to do that, but not for really that much, just up to 10%. Highly compensated employee exemption threshold was going to be increased to $134,004 per year if the final rule goes into effect. The duties test remains unchanged, whether the final rule goes into effect or not. We'll talk more about the court's ruling and what the court said about the duties test, but the rule didn't change it. The notice of proposed rulemaking that was published about 1.5 years ago, there was a lot of discussion about changing the duties test and making it more similar to the California rule. But ultimately, the final rule didn't incorporate any of those proposed changes. Under the current regulations, the term primary duty means the principal, main, major, most important duty that the employee performs. There are a lot of factors that are reviewed in that. Time spent performing the work, supervision, the relative importance of each duty. So there's no additional, what is not changing on December 1st? Well, again, nothing, but there's no additional slack on showing the employee meets the duties requirements. just because they're paid more now. So that was something that we were trying to stress to employers that were implementing changes in anticipation of this rule going into effect, is that you can't just, that was a really good time to look at each employee that was exempt, why they were exempt, what duties they were performing, and really educating employers about the fact that even if they, can afford to pay their employees up to the $47,000 amount that the final rule was going to put in place, even if they can do that, employers still need to make sure that employees are actually performing the duties that go with the corresponding exemption. So even if that employer can increase the salary, the employee still might not be properly exempt and still might have to be an hourly employee. So this outlines various steps that employers can take in trying to implement this rule. Of course, the timing of which is kind of up in the air at this point. You can identify exempt employees whose pay is currently between the previous threshold and the new threshold, and then those highly compensated employees whose pay is somewhere in between the $100,000 and then the new threshold of $134,000. Then employers need to assess what they can do and what they need to do. These are just various questions that employers can ask to try and do that. Once employers have answers to some of those questions, they can make a decision on those affected employees, whether they can afford to keep them exempt, meaning, raise their salary to the new threshold amount, or whether they need to move them to a non-exempt position, which is easier said than done. You can't just, the employer still had to determine how many hours is this employee working, what's an hourly wage that I can afford and still get the work done that I need to get done. And that's a difficult question to answer for a lot of employers, particularly those who don't keep track of how much their exempt employees work, and a lot of employers really don't. And then the next step is really communicating the changes to employees. If an employee is changed from exempt to non-exempt, they need training and reminders on how to track time and how life is just different as a non-exempt employee. So recording time, getting approval to work more than 40 hours a week, adjusting work routines where necessary. For example, if you've got an employee who always comes in early, eats through lunch, still stays till 5, that employee is going to be, eligible for overtime. Encouraging those employees not to work off the clock, educating them about how accessing emails, making phone calls, even from, your house on nights and weekends, that's working, that's considered work. And so it's a challenge, one, learning what the habits are of various employees, and they're going to vary, but then working to encourage and educate them to change those habits to comply with the new position that they're in. So you can increase the salary to make them exempt. Here's various options for complying with the final rule. Move to non-exempt, pay employees hourly, pay them overtime over 40 hours per week, but limit overtime to control your costs. Move to non-exempt, pay them hourly and reduce the hourly rate so that the total compensation with overtime remains about the same for your book. Move to non-exempt, pay on a salary but pay for overtime. Hire part-time workers to offset reduced workload of employees that are now working less. Reduce benefits and other costs. Those are the options. Now more than ever, I think that how these changes were communicated, if they were already communicated to employees, is really important with what the employers do next. For example, I've heard over and over about how it affects employee morale when they go from being exempt to non-exempt. There's this kind of fake prestige that comes with the salary. So how the employer, a number of employers have already tried to implement this rule. And for them, they're really in a pickle because if they try, they've got a decision, they can unwind the steps that they've taken. They can keep those in place just in contemplation of maybe the final rule will go into effect later down the road. But for employers who try to unwind, the way that they communicated these changes will be really important. I know of one major employer that we worked very hard with them and their employees to educate their employees about the fact that going hourly had, it wasn't a demotion, it had nothing to do with them as employees, and that they actually would probably get paid more now the way that it all worked. And so now if we go in and try to take them back to salary, I think that could just be really detrimental to office morale and employer retention as a result. So, for those employers who have already communicated these changes and tried to implement these changes, the manner in which they did it and the choices that they had to make to do so are really going to be determinative in my mind on how they're going to approach the fact that this law isn't going into effect now on December 1. But yeah, there's this, just generally speaking for salary, it's just a fake prestige. There's nothing magic about being salary other than the fact that you can work way more than 40 and still get paid the same amount of money as whatever your arrangement is with your employer. So why that's grown to be, in our society is some important factor, I don't know, but employers have to educate their employees about that for sure. Advancement being salary or non-exempt, that shouldn't have any impact on advancement. A lot of employees had questions about whether they were going to make less money, and that answer depended. I think it was generally no, depending on the way that their employer had to adjust to this rule. Some employees will be working a great deal less because just computation of their overtime, it wouldn't pencil out for the employer, so it's cheaper for the employer to maybe hire someone else to come in part-time and supplement that same person's role. Loss of flexibility, that was kind of the number one morale issue that I saw. I think that there's just a general more leeway is given to employees who are exempt because they understand that they can work late or they can work through their lunch the next day or even more hours. So maybe they felt more free to go to a doctor's appointment or leave for an hour and a half lunch. Other communication tips. Making sure the person communicating clearly tells employees that it's a change in the federal law that has nothing to do with the employee and why the changes had to be made. Training managers and supervisors about the changes and why they were necessitated. Training new non-exempt employees on how to keep record of their work can also be really difficult. It's for somebody who's never, if you don't have to ever clock in, all of a sudden learning that you have to clock in and out every time you come to and from work can be hard to get used to. So opportunities. Opportunity to conduct a full review of classifications and job descriptions. That's one of the best things that has come from this rule, really, is that employers had and still have an opportunity where this impact of the law was big enough that it justified reviewing their job descriptions, it justified reviewing the exemptions that they had in place to make sure that it complied not just from the salary standpoint but also from the duties test perspective. So, for anybody who came in a little bit late, I premised the presentation by last Tuesday, a federal judge in Texas. His name is Amos Mazant III. He was an appointee of President Obama in 2014. He entered a preliminary injunction nationwide, making it so that this rule didn't go into effect on December 1st. So it was 9 days before the rule was supposed to go into effect. The 21 states, including Nebraska, filed an emergency motion for a preliminary injunction in October. There were also a number of various business groups, the U.S. Chamber of Commerce and many others. I think there was over 100 that filed a similar lawsuit in the same court before the same judge. Those actions were consolidated. The business group, they actually filed a motion for summary judgment, but the judge said that he could essentially grant the type of relief that they were seeking in that motion by consolidating the suits. So he consolidated the suits, and it's actually a really well-written order. It's about 20 pages long, but basically the court went through the criteria for, for entering a preliminary injunction, and for that, and I had to, re-up what all that took and what that burden was, but you have to show that there's a substantial likelihood of success on the merits of the case, which is a high burden. You don't actually have to prove your case, but you have to show a substantial likelihood of succeeding. You have to show a substantial threat to the plaintiffs that they would actually suffer irreparable harm. The injury has to outweigh the actual damage, the injunction. So the injury of putting the law into place has to actually outweigh the damage that the injunction would cause. And the injunction, should not disserve the public interest. And so that's the analysis the court went through. What I thought was interesting is that, there were the bits of it that the Department of Labor chose to contest versus what they just accepted as true was interesting to me. There weren't standing challenges. I thought there would have been a number of standing challenges, at least to the business groups. There was also some interesting arguments about the current state of the law on Congress's ability to impose FLSA requirements on states. And so the court said, though, they were going to follow the current law, which is Garcia case. It's the United States Supreme Court case that said, no, Commerce has the ability through the Commerce Clause to impose FLSA on states, and it applies to state governments, local governments too. So, but it was very interesting. The main problem with the rule was not that they changed the salary. They've changed the salary 7 times since 1938. The department has. They go through a process of rulemaking, there's comment period, and then a rule is published sometime later. I think it can vary in how long it takes. I was surprised when the rule came out in May. I thought it was quicker than what it had been forecasted to be published. I think that it might have had to do with the election. So it was published in May and to be effective December 1. But the real problem that the court had with the final rule was that the salary, which was doubled, and granted it hadn't been updated since 2004, so that's 12 years, but it doubled the salary threshold. And so what the court said was that it essentially made it a de facto salary test, and that the duties test, most of the time, no one would even have to go through that analysis because the salary was set so high. The court also had a problem with the fact that it was just automatically increasing. So that's without any notice of proposed rulemaking. That's without any comment each time. Although I anticipate if the Department of Labor, when they respond to this, they will state that in our original notice of proposed rulemaking for this final rule, that's where we discussed the automatic update. That's where the public had the opportunity to comment on it. But it just essentially came down to that the law, USC Section 213, the whole point of it, it turns on the duties of the employees. So for the department to increase the salary threshold so much, you have not followed Congress's intent, which they interpreted as being unambiguous. And some of the states, what else I found interesting is not all 21 states were on equal footing with how they proved the irreparable harm. The opinion talks mostly about Kansas, and so I don't know if that means they just put on more evidence or not, but the court said that we're not just going to apply this to the states that are parties to the suit because it's a federal law. It's effective everywhere. It's going to cause, the fact that we've found that it's going to cause irreparable harm in some states, we believe that means it's going to cause irreparable harm in all of the states that it's implemented in, particularly if, the lawsuit is eventually successful and they determine that it's an unlawful law for good. So the court exercised its discretion to apply, to block the rule everywhere. The most common question I've gotten is, so do I have to do anything by December 1st? If I haven't already done anything, do I still need to change anything? And the short answer is no, you don't need to change anything. I think it's still a good opportunity to be in front of your clients and say, but who are your exempt employees? And are they really performing the duties that are necessitated under, that particular exemption? Because a lot of times we don't have that many opportunities to just bring that back up and put that issue back in front of their face. But no, employers don't have to do anything to comply with this law at this time. And, I have no idea when they will, if at all. Another question, so is the rule, off the table now? And the answer to that is no. The order granting the preliminary injunction is just that. It's a preliminary injunction. It's not permanent. And the court will have the opportunity to decide whether or not the final rule goes into effect. We've already talked about this, but this is what I found to be really the turning language that, in the decision, where essentially the duties test has become meaningless. And that doesn't sit right when you analyze the federal law that shows Congress's intent truly was for it to turn on the duties test. So what should employers who have already raised exempt employees' salaries or reclassified employees to non-exempt status do now? The answer is going to be different for each employer, each of your clients. Employers will likely want to leave the decisions in place, or many employers will likely want to leave the decisions in place until a final decision's been reached in the lawsuit. I mean, this really puts companies in a pickle, and I think it just depends on how they had already implemented the rule, if they had. Did they raise salaries? Was it a big raise? What type of impact was that going to make on the company? Have they switched employees to being non-exempt? And how they communicated that to their employees. I think that's probably the biggest deal. How did you explain this away? And are you going to be talking out of both sides of your mouth if you go back and try to meet with them again and undo this? And so going through a pro-con list on what the financial impact is, what the potential office morale impact is, that should help each particular employer decide what it is they can do or what they should do. Does anybody have any questions?
I read this morning that the biggest circuit history for a couple of decades, very sparingly one-count injunctions.
Mm-hmm.
Very strong enforcement. Don't know what that means. Who knows? I didn't give this much of a chance to the beginning.
Mm-hmm.
I did read that. History of injunctions. I believe what the judge said. I think everybody knows what direction he's in.
Mm-hmm. I thought it was really interesting that this was an Obama appointee. When I was reading about that, when the rule or the opinion first came out, I don't know, did anybody follow the Trump campaign at all? I mean, I saw things on the news, but I didn't follow it as closely as some people. But I mean, one of the things that he's promised to do is dismantle this law, and that's when it was in effect, which would be much more difficult to do if it actually had gone into effect than it would now. I'm wondering if, I think that the Department of Labor, the tone might change. They don't have as much, if the Trump administration, when he is president, doesn't support this law, I think it's possible that the department might not vigorously try to defend it. And so there's the potential now that it could just die on the vine, which would be a lot easier than had it gone into effect. So it would be a lot easier for Trump now, if that's really something he was interested in. I know both campaigns, all campaigns make lots of promises, and maybe there wasn't a strong desire behind it, but it's looking pretty gloomy from what I've been reading that it'll go into effect. Gloomy from the standpoint of I don't know what its chances are, but it's a pretty controversial rule just because I mean, doubling the salary threshold is just such a big change. What I find difficult too is how it's not different for the various geographic areas in the nation where salaries are much different in New York than they are here, and the rule doesn't account for that. Neither does the current regulation. The 2004 regulation doesn't account for that either, but they seem to just kind of go along with what the analysis was in 2004 when they raised it here.
Do you know if they have a salary requirement in 1938?
Yes, I don't know what it was. The only salary requirement I know of is the current 2004 one.
I'd be curious to see how they decided that. I mean, it sounds like it's
I know that it's been updated 7 different times since 1938. So it's been,
did they have some sort of formula then?
I don't know.
It sounds like
I would assume so, yeah.
50%.
Yeah, this is the 40th percentile annual wage earners, yep.
You can kind of get a better idea of what the congressional intent was based on what they did in 1938. I suppose.
Yeah, that's a really good
If
idea.
If they base it on 40th percentile of this, then you think you'd have a pretty good argument that it just hasn't kept up with inflation.
Right, right. I don't know the answer to that, but that would be interesting, and maybe that would be an arrow in the department's quiver if they...
I suppose you can go back to the Census Bureau's numbers for 1938 and figure out, look to see what the original rate was and kind of back your way to the plan.
Sure, absolutely. I'll send that to you. It's not long, 20 pages. It was really well written. I'm sure the judge had a lot of work to do in that. You know, I think the hearing on the motion was on the 16th of November, and then he issued the order on the 22nd, so that's a pretty quick turnaround. But I'm sure he knew that the closer you get to that December 1 deadline, the closer you get to employers implementing the rule.
So do you know, is this an appealable order?
Yes. I believe I read that this morning, actually. Yeah, that they can challenge the injunction.
And a nationwide injunction issue, an environmental issue. It's different from this, but essentially, this issued as a nationwide injunction with several other circuits just said, look, it doesn't apply to us, it doesn't bind us, because you made this determination to bind your circuit. So, is that what you were referring to, what the Fifth Circuit was talking about? And then even the other circuits weighed in?
Not that I know of, no. Has anybody else read anything about other?
All the headlines I've seen just basically said it's nationwide and everyone's assuming that's
Blocked. Yeah.
That's what it's going to be.
Yep.
My case was the Corps of Engineers decision, or rule that the Corps of Engineers was trying to, and the sister circuit next door just said, we think it's bogus what you did, we're not going to allow it.
Really? Well, that would be really interesting. Yeah, I haven't heard that.
Are there any other challenges to this in the other circuits?
No.
I think they all got together and filed the same circuit.
Yeah, and because of the docket, apparently the docket was moving really quickly in Texas.
Did they choose that location deliberately?
Because they thought they could get their motions heard before the rule went into effect.
Sure did they expect to get the Obama?
I don't know.
Actually,
Maybe.
I don't know. I've heard a little bit on the other side of it. This is the judge they wanted. Just because he had a reputation for, I think, being thoughtful, deliberate, and a rules-based practice.
Very
You
good.
never know what a judge is going to do.
Any further thoughts on, there were some employers I know that implemented this because of the way the payroll was spelled, like 15 months, so they would have had half a payroll an hourly, half a payroll a salary, so they started early enough, the paycheck would encompass one payment. They started that. Any thoughts on how you might go about unwinding that?
Well, I think that depends on,
Whatever communication they didn't do yet.
yeah, not just communication, but also impact on the business. I mean, if it was, for one of the employers that we counsel, there's this one sect of their business, they do research. And those employees all through the winter only work 4 days a week. And that's why those employees love that job. And then they work 5 days or 6 days during their busy times. But they were exempt, met an exemption, but their salaries were all, 40, 42, 43. So their employer just said, we'll just bump you up. And so they didn't change the way pay was calculated, but now I think they'd have a really hard time going to those employees and saying, we're going to take away that $5,000 we just gave you, or $7,000. So I think they're probably just going to eat it. And, maybe, I don't know, maybe their salary increases will be less for a few years, but actually changing, I think employers can change it back. I think,
I didn't see a notice where the employer basically said the sole reason this is occurring is this change in measures. So if you based it on solely on that.
Yep.
But you probably had to do some persuasion for those that might have been moved one direction or the other.
Mm-hmm.
And they're going back, drafted, said it was solely based on the law. Now the
Yep.
law's in flux until we have a better understanding of where it's going to end up. We're back to where we were.
Yep. And I think that's a completely legitimate way to communicate that to your employees. The employers who said, you're probably going to get paid more this year,
That's the hard-
and this is better for you.
It's better.
Yeah. And all the while knowing, even though it looks, I mean, it looks to me, I don't feel like it's ever going to go into effect, right? But I don't know that. So employers also have to realize that if they undo a change that they've already implemented, you know, it's one thing not pulling the trigger, but if they undo a change and then the law does go into effect, what does that tell their employees? So it just makes communicating all the more important.
Especially your retroactive application.
I wouldn't think so. You mean if it didn't go into effect until February and,
Preliminarily enjoined by
uh-huh.
rules to be implemented by December 1st. I haven't looked at that issue.
Oh, enforcement of that would be such a nightmare. Yeah. I don't know. I suppose that depends on your Department of Labor. It's probably within their purview. That seems pretty difficult, especially with, you know,
Well, the law is already will be in effect. You're just enjoined from enforcing it, right? The injunction just goes to enforcement, or it does an application.
it's not implemented, is the way I read that opinion. Yeah.
Probably been having authority to issue. That's what I think the judge said.
Yeah, and it's regulatory.
Right.
Mhm.
If you go look at the federal law, it's very clear as to what an exemption is. You have to go look at the Department of Labor's regulations, which go on forever and ever. Starting with the duties tests and the stop tests and all these things. And
Yep.
that's the problem.
Yeah.
No, not really. And like Old Baby's website, I can't even get on.
Mhm.
Yeah.
Mhm.
If I can get on, I'm going to just spin and spin.
So you are, and then carry the way.
Yeah, I don't know.
Well, and it rendered the duties test
Oh, yeah.
unnecessary, I think, is the real
And I think
problem
that was
with
the
it.
whole point of the legislation.
Mhm.
Was, hey, just raise the salaries to such a level.
Right.
We don't have to worry about duties.
I know. And that's not what the law says. Yeah.
But you can still pay lawyers and teachers whatever you want because they're not subject to the salary. It's,
Yeah, it's very interesting. It's sad if you think about all the money that's gone into it. I mean, clients that client costs. We've done a lot of work just internally educating, yourself about the law, and
well, I hope you got prepared for Y2K.
yeah, yeah.
For those who were around then, said, oh yeah, the computer's going to shut down. But then also persuader rule. There was a nationwide injunction against persuaders that came out just recently. This is like the second one that a federal judge comes down. So those are going to go into effect.
It pays to procrastinate. For like your employers who just weren't. All right. Well, thanks for listening. I'm sorry the whole conversation was much different than I anticipated. But yeah.